Okay, I'll talk to you guys anyway while we're starting. Excuse me. So I am teaching today. I'm Lindsay from the Attorney General's office, and my friend is Jennifer Mamega, and she was going to be teaching today, and she was actually arguing an Eighth Circuit brief today in front of the Eighth Circuit. So she asked me if I could cover, and I'm happy to do that. It actually worked out good because I was in here this morning working on some exhibits with our Office for a Murder Trial we have coming up. So, as the introducer said, I worked on murder cases, aggravated assault, burglaries, rape trials, drug conspiracies. I transferred from that Rapid City office where we did a lot of drug stuff. And so since I wasn't here earlier this morning, I'd kind of like to know, what do you guys, how many prosecutors do we have here? I see a few from my office. So, okay, I can kind of tailor that. Okay, we have a lot. Anyone work with criminal defense? You raise your hand. Okay, so you do both. Okay, I can kind of tailor it that way a little bit. Oh, either one? So this doesn't work. Okay, that's okay. I'll hit it. I can just move this too. So I'm going to go through just some basic criminal procedure stuff. So this is just kind of basic intro. But basically, okay, so you have a crime that happens, and as you guys know, there's two options. You can either indict the case, or you can take that case to a preliminary hearing. Two options, and there's some things that are going on behind the scenes before you actually take that case forward with the charging document. And some things that are...
Anywhere close.
All right, thank you. And charging decisions are really important at this phase, as prosecutors know and defense attorneys know as well, because you're looking at that charging document when you're going to trial, and that's something that can be attacked. So, prosecutors have to be very diligent when they're actually drafting the charging document. There's a few things to think about, whether you're going to be charging your case as co-defendants, you're going to be bringing them all together, whether you're going to split it up and have it one at a time. You also need to be thinking about alternative charges and future arguments of multiplicity and duplicity. As Bob Mayer, I guess, in our office would say, you indict a case, ready to try it. So you're not going to be overcharging it. You're not going to be thinking, well, I'll try to just plead this away later. If you indict, you better be ready to go to trial, at least from a prosecuting standpoint. But what would apply to both prosecutors and defense to look for stuff like a multiplicitous argument and a duplicitous argument. We had a trial in September that we took over a case in a different county, and it had already been charged out and the prosecutor was sick. And unfortunately, the charging document had a list of alternatives. It was an attempted murder case that was charged out with aggravated assault and burglary as well. And the particular crime happened to fit pretty much every element in aggravated assault and in burglary. So the prosecutor, and rightfully so, had charged out each alternative within that document. Defense gets this, and we're right before trial, and they make an argument to dismiss the information, alleging that it is multiplicitous and duplicitous. And the judge reviews it, we brief and go back and forth, and ultimately the judge upholds the charging document. But it's just something to really be aware of. And the prosecutor and I were working on that case. We ended up, although the charging document was upheld, we ended up choosing, just because of the complications with when you're looking at a document that has that many alternatives listed, we ended up electing to proceed on, we chose one alternative under each of the counts that was listed just to not confuse the jury. Because if a judge is confused and defense is confused and throwing all these arguments, a jury is going to be really confused. So we ended up getting a conviction on that, but it's an argument to keep in mind. Another fun thing that I like to do, I guess in Rapid we did a lot, is charging out conspiracies. You guys are probably aware of that, but it's just a good way to get charges done. And one of my favorite cases, actually, when I was starting, was a case with marijuana. It was about 30 pounds of marijuana. We had a string of decoy vehicles. They were transporting drugs on the highway, and there was 3 vehicles. The first one gets away, so law enforcement never stops that vehicle. The middle one and the last one in this string were stopped. The middle one doesn't have any drugs in the vehicle. The last one has 30 pounds of pot in it. So through investigation, they were able to link these 2 vehicles together, even though no drugs or any connection other than some fast food items found in this middle vehicle. They were able to connect the second vehicle And it turned out that this woman who was driving the second vehicle with no dope was the kingpin running an international drug operation. Truly. I mean, that was one of my first conspiracy cases as a brand new prosecutor. I was like, whoa. I mean, she was investigated federally, and we were able to bring in a federal cooperator to testify against her and says, yep, she's the one who runs the show. She'll never touch the dope so that she doesn't get busted. She transports cocaine all across the country, usually from California to the East Coast, and there's an international operation too, and she runs the U.S. portion of it. So because we were able to use a conspiracy, even though she didn't have dope in that car, we were able to connect her and had to work really hard. It was thin, but we got it. We connected her to that and were able to charge her out as co-defendant and got a conviction. And she becomes defendant. So that was a cool case and a fun one. So you can really get creative with conspiracies, and it's a great statute and charge to use. Okay, so most of you probably know that, again, and like I was saying, once you figure out how you're going to charge it out, you have the two options, which is grand jury or going to a preliminary hearing. If you're going to go to a preliminary hearing, the first document, well, it could be filed either way, you can indict. But a complaint will be filed so that there's probable cause to go forward with the case. So that's just to get it started with the court process. Whether they're arrested or a prosecutor can file a complaint as well and then later choose to get the preliminary hearing and go forward that way, or to indict. So that's your first step. Grand jury. So once the complaint is filed, so there could be a complaint already filed, or you could just start out straight with grand jury. Sometimes in the racket office, when we get distributions, we'd be going after dealers who are distributing meth and stuff like that in the community. So the agents would bring us the reports, and they'd say, I've been holding on to this for just a couple months because the CI, the confidential informant in this case, is still active, and we weren't ready to indict until today. So this particular person, they're not in custody yet. So we would just take it to the grand jury. There hasn't been a complaint filed against them or not, yet. So we could take it to the grand jury, and a grand jury consists of 12 people. You need to have a vote of 6 to 12 in order to indict. So that would go with an indictment. Again, now, you could have a person, let's say there was, from a prosecuting standpoint, but this would apply to defense as well. But you could have a person who's arrested the night before and they're in custody, like there was a search warrant done, and they had meth in their house, so they're arrested and they're in custody. Well, now a complaint will have to have been filed to keep them, and so you have time frames that start ticking. We have to either indict within the next time possible, within the time frame, or a preliminary hearing would be scheduled, and then we would go forward to the preliminary hearing. And a preliminary hearing has a judge, the defense attorney, the defendant present, and then the state would call whatever witnesses they want. There's pros and cons to that. The good thing about a preliminary hearing for both sides is that you get statements on the record above just your law enforcement witnesses, and that can be helpful in cases where, let's say, you lose a witness later, and then you want to be able to use their testimony if they become unavailable later. Here you have them subject to cross-examination and under oath at a preliminary hearing. Whereas grand jury, you wouldn't have that option to use their statements later because you did not have a judge present. They weren't subject to cross-examination by the defense counsel. So that's just two ways to get the case going. Okay, so an arrest after the complaint or the indictment has come down. I'm skipping a couple because you guys have this experience. So after you get the indictment or the preliminary hearing you have the preliminary hearing and it's bound over, meaning it would just go up to circuit court if you're doing a felony. It's a misdemeanor. Actually, you don't have to have either a preliminary hearing or an indictment anymore. That's recently changed. So if it's a class 1 misdemeanor or a class 2, prosecutor can just file a complaint and it will be set, and a judge will simply determine probable cause based upon the reports that are in the file. So you don't have to go through the hearing and stuff like that. I think there's different opinions on that, but that's what the law is now. So once that happens, again, when you have the indictment and you get the arrest warrant, then the arrest warrant is active, and law enforcement can go after the person that has been indicted if they're not already in custody, and they can pick them up, and bond will be set as well on that document. And then so sometimes the prosecution or the police officer will request a bond on there prior to a bond hearing. And so sometimes there'll be an amount listed on that arrest warrant, and it'll say a certain amount So they'll have to go in and get processed, and if they can't make that amount, they'll sit in custody for a while until they have a hearing, and then you argue bond again. She also talked about an initial appearance in here. Defendants are also all entitled to an initial appearance on their charging document, and that's even before the arraignment. They can choose to waive that if they would like. Sometimes after a defendant has been indicted, I've had defense attorneys a lot of times say, yeah, we'll waive the initial appearance. They know the charges that are brought against them. Let's just get this on for an arraignment to get the case moving. They haven't had counsel appointed yet. An initial appearance is the time that they would get that appointed, and the state would typically argue bond as well. Talking about failure to appear as well, once an initial appearance has been set, or other hearings as well, can have an additional charge if the defendant fails to appear either for a misdemeanor or a felony that has been scheduled. If it's a felony case and it's their arraignment, let's say, or actually any hearing that has been scheduled and ordered by a judge, and if they fail to appear, you can charge them with another felony. That happens sometimes. Sometimes, a lot of times, people fail to appear, and I know in my experience in Rapid City, a lot of times that charge wouldn't be filed because people fail to appear so frequently. But it does happen. And it can happen for misdemeanors as well, and that would be a misdemeanor charge. Okay. Talking about the preliminary hearing here again, talking about the amount of, for the last slide, the amount of time that you have once you're in custody. When a person's in custody, they have 15 days that the preliminary hearing has to be set. So the prosecution will either have to go to that preliminary hearing or indict within that 15 days if they're in custody, otherwise the case will be dismissed. If they bond out and they're out of custody, it'll be 45 days. Okay, so here's some of the documentation that will be coming forward after the preliminary hearing. We file, if you go through a preliminary hearing, the prosecution will file an information, and for defense that will then be the documentation that they have for the charges going forward. Otherwise, it would be an indictment that will already have been filed with the court that the grand jury will have signed and turned into the court and will be filed. If the defendant has a prior criminal history, we can file also what's called a Part 2 information, and there's statutes that cover that. That's if they have one or more prior felonies. The state would need to file this Part 2 information at the time of the arraignment, and statutes cover this as well, and depending on how many felonies they have and how violent it was, that'll knock up the maximum sentence that they're exposed to. So this, again, needs to be filed at the arraignment. There is an exception by statute that it can be filed 30 days before trial if a judge finds good cause, but it's best to just file it at the arraignment. Okay, and at the arraignment, you guys are all familiar, but at that point the defendant would typically enter a not guilty plea. It's rare that, at least in my experience, that they would plead guilty. The judge will advise them of all the rights that they have and the charges that they are facing at this time. Okay, pre-trial, you're going to be, after the arraignment, it's going to start the pre-trial actions. And depending on how your circuit is, in Rapid City, they would schedule out-of-status hearings and stuff like that, and non-evidentiary motion hearings. I'm sitting in Sioux Falls, although I haven't been there long, but we'd have the arraignment, and then a pre-trial date or a change of plea date would just be set right away, so we have to get everything done that we're going to be doing pre-trial on our own in between that time. But at this point, defense can be filing suppression hearings, or suppression motions, and you have a suppression hearing. Different motions will be filed. If we're going to be going to trial, we'll be filing, the state would be filing other act motions, and everything consistent with the evidence that we would like to bring in for a jury trial. Again, notice of alibi defense, that'll be on, we file those with our indictment or our charging documents, and defense would have to provide that to the state within 10 days of receiving that, or it could be kicked out. And the alibi that they have to provide is very specific, and it's covered by statute. They have to provide an address, they have to provide place of, I think where the person can be reached, but full name of this person that's going to have the supposed alibi, and information where they can be found. I've had that happen before, actually. One trial that my office has worked on a lot, particular, so they're very familiar with that particular case. It was case State versus Derek Weiss, and he was a defendant that filed a ton of different motions for us, and it was a drug distribution, one of my first jury trials. But he filed an alibi defense that he didn't list all of the appropriate names and addresses and contact information where we could find these witnesses. The judge still let it go forward, and we ended up, fortunately, we were able to contact a lot of these people because he at least had written the bare information, but the judge did let it go forward. And because he had filed the alibi defense, law enforcement was able to contact all these people and kind of head that off before trial. But should just still filed a 10-day notice in case a judge would follow that strictly. Okay, so then you get to a jury trial, and jury trial would consist of 12 or more people of the community of the county. And to start with, the basic stuff, opening statements, you're calling your witnesses, closing, arguments, jury instructions. An important thing is voir dire, and Jenny lists this on here. Recent case law has really emphasized jury or challenges during voir dire that are based on race or gender, and that's called a Batson challenge. So something to be familiar with, that state if you should probably be ready, I guess, on all of your voir dire cases with a relevant case law. And there's a case law in South Dakota that lists the 3 elements that the state will need to show, or need to argue, or that the judge, I guess, will have to find on the record to overcome a Batson challenge. Defense is typically the one that makes it, although in a trial about a year ago, the state, we did make a Batson challenge. So the state can make it as well, can go both ways, but just an issue to be prepared for when it's gender. They have to make a prima facie case that there was a discriminatory, that there was either a racial element or a gender element. And then the state has to show that they did not strike, or defense, I guess, strike that person based upon race or gender, and the judge will have to balance that on the record and make a finding. So that all 3 of those have to happen on the record, or that can get overturned. And it did happen in Pennington County where it got overturned recently. One thing I think that I skipped over here was pleas. So I'm going to go back to that again. I'm going to skip that page. But change of plea, when they get ready to do that, so if you're not going to jury trial, and the defendant is going to be entering a plea, they have to be advised of all their rights. And this is something that both the prosecution and the defense really need to watch for, because sometimes the judge has a full docket that day, and they're running through everything really fast. But so the prosecution needs to be aware of the Boykin rates and be ready to be checking that off and covering the record, because we're all responsible for that. It's everyone. It's a team effort there for defense too. None of us want, first of all, none of us want a defendant to not be fully advised, but we also don't want to be retrying that case. And an issue that has come up recently in my office is Padilla. Probably many of you are familiar with that, but the Supreme Court case. And it talks about deportation, and this is really important for change of pleas, because we just had a case, and it's actually a case where the defendant has been accused of rape and sexual molestation of a child. He entered his guilty plea. My coworker and I knew that he was deportable, and we made sure to have that listed on the record, that he was, and we wanted to make sure that he'd been advised of that prior to his entering the change of plea. And defense said, they said they weren't familiar with that case, and it's just an important one to look at. So they took a break and advised him. And we're going through this, and he's going to be allowed to withdraw his plea now because defense did not fully advise him of deportation consequences prior to that. So it's really important. And the case says a general advisement is not enough in cases where they've committed an aggravated felony and it's likely that they're going to get deported. So for defense attorneys, you telling a defendant it's possible you might get deported isn't going to be enough. You have to go through with them a specific statute and tell them exactly where it falls within immigration laws, which is kind of a lot for you guys to have to do, but it's important. And now if it's a case that it's not automatically deportable, then Padilla does say that a general advisement is enough. But it's a big issue, and right now we're having a case that a defendant is withdrawing his plea, which, I'm glad you know that now, so that we're not coming back later and retrying the whole case and doing a habeas. So, okay, we talked about trial and the different verdicts that you can have. You can have guilty, not guilty, or hung, and you can have it on different counts too. We've seen that before, where they've been guilty on some counts and hung on other counts. Okay, and sentencing now. When you get to sentencing, assuming, in this case, I guess, when a defendant has entered his change of plea, sometimes that he'll be allowed to, if he wants to say, he or she can say, well, I can waive my 48 hours and proceed to sentencing. but there has to be a 48-hour period in between the change of plea and sentencing, or they have to waive that on the record. And so prosecution and defense both need to make sure that that's very clear on the record if they are going to be waiving, because that has happened in cases with me a lot where they decide to do that. They're just ready to pursue the sentencing. Then they don't have a pre-sentence investigation if they choose to do that, which is their right. That also just needs to be really clear on your record. So they can also, typically what happens is they'll enter their change of plea, and the judge will order what's called a PSI, or a pre-sentence investigation, where they get together their criminal history, a lot of their other history, court versus officer will talk to them. They'll get a statement about the case, and then the judge and both sides of the case will be able to review that to give appropriate sentencing recommendations. There's a different type of sentences that a defendant can receive. Suspended imposition of sentence. Here, there's no technical judgment of guilt that's entered at that time, and if they comply with all of their probation recommend or guidelines set by the court, then at 2 years, then they receive the actual suspended imposition of sentence, and guilt is not entered at that time. A judge can still order time, or some jail time, not pen time, but they can also order conditions of probation, and they typically do. But it's an option that you can't have a prior felony if somebody's going to be applying for a suspended imposition of sentence. They can also receive a suspended execution of sentence, and here the judgment of guilt is entered right away, and they can have suspended penitentiary time, and then they're usually given typically some county jail time and probation as well. Or they can have a straight judgment of conviction, or they're just given the judgment right away, no time is suspended over them. They're either sent to the pen or they can have probation. The suspended time really comes into play when you have a violation later, when they're on probation and you're filing, let's say, a year later somebody hasn't caught you in, and so the state is going to be filing a probation violation against them, saying you violated this, you're coming back, and you might be, there was 10 years of pen time sentenced against you, back then that was suspended, and we're going to ask that it be imposed now because you didn't comply with your probation. Okay, then after you're all done with sentencing, it's important for especially defense, I guess in this scenario, to be cognizant of the appeal times. They can file for appeal within 30 days after the judgment of conviction has been entered. So the state will propose it and the judge will sign it, and after that your appeal time starts running. So appeals need to be filed within that timeline. Also, the defendant can petition for habeas corpus relief, and there are guidelines that apply to that as well. Federal and state. Federal needs to be filed 1 year within the judgment of conviction, and state needs to be filed 2 years within the judgment of conviction. Another option is 1983 claims, where they allege mistreatment while they're incarcerated or a violation of the federal or state constitution, or U.S. Constitution. And that is all I have for you guys. So any questions? Yes.
I got this question and I wasn't sure. I know a suspended position is you get one in your lifetime. Is that across the nation, or you have a suspended position in South Dakota and then have another one in another state?
That's a good question. It's my understanding that it's across the nation, and I guess if anyone else has a different, Phil maybe has different opinion.
If you're talking about a conviction in South Dakota, what I've typically seen is that if you have a suspended imposition from some other state, then you are not eligible for a suspended imposition in South Dakota.
Okay.
I don't know how other states would handle it, but that's what I've seen.
I agree. Thank you. Good question. Any other questions? Thank you.